Hello friends and welcome to the channel's first ever election case. This is the Supreme Court Historian YouTube channel and we are tracking the judgments of the Supreme Court of India in its 75 years chronologically, and we have finally arrived at our first election case because this is when the first elections were finally taking place in our country. The judgment was given out on the 21st day of January 1952, almost 2 years into the Republic, and this is NP Ponnuswami versus the returning officer Namakkal. As ever, we will begin with defining some of the terms that are going to be relevant in this discussion, and I'm going to start a separate playlist for election cases, and this particular case will also be included in the jurisdiction cases playlist, and perhaps an interpretation of statutes playlist as well, because it covers all of these aspects. A very interesting case as ever, and therefore included in our collection. Let's start with the returning officer. The concept is not really discussed often. The nomenclature seems a little weird, but it is actually quite straightforward and logical. The officer that is appointed by the election commission to go and conduct the election and to come back to return with the winning candidate. That is why that person, that official, usually or invariably a gazetted officer, is called a returning officer. He or she is expected to return with the winning candidate, of course, of the election. And that brings us to our second definition: election. What really does it entail? What all is included in it? And this differentiation between what is and what is not part of an election process is what this case turns on. There are two interpretations. There is a narrow sense of the word election, which deals with just the specific act of selecting the candidate. The selection is done, of course, by we the electors, we the voters, we the people who go and vote for our particular candidate, for the person that we want to be chosen. So in the narrow sense, election would imply only that, the actual process, the actual act of voting and selecting, and then the declaration of the result, either because there was voting required or because, if in case there was just one candidate, then that person was elected unopposed. So that narrow definition really talks about just that one day when we get a holiday because we are expected to go and vote on that day. There is a broader sense, though, a wider sense, in which the entire process of an election is included. So when we say election, we mean not just the day of polling, but all the way from the beginning when the polling date was announced, which resulted in the imposition of the model code of conduct and everything that came along with it. Then the date for filing your nominations, for withdrawing your nominations, for scrutinizing the nominations, rejecting the nominations, then the end of the campaigning, then the actual voting day, then the results, and then the certification of the result. All of that would be included in the definition of election if it was seen in a wider sense. And that is what Mr. Ponnuswami was arguing against. According to him, the election should be, when we refer to election, we should mean only the narrow sense, that is the actual voting, and not everything else in the wider sense. And the reason he was making these arguments was because of these facts. He had filed his nomination from the Namakkal constituency for becoming the member of the Legislative Assembly of Madras from that particular constituency. Namakkal was part of Salem district back then. Now it is a district in its own right. And Mr. Ponnuswami wished to be elected from there, and he had filed his nomination for that MLA seat, and his nomination was rejected by the Namakkal returning officer after whatever scrutiny that officer is expected and duty bound to perform. The reason for rejection is not included in the judgment. In fact, the Supreme Court has specifically stated that it is immaterial what was the reason for his rejection. That does not matter. What matters is what happened next. What happened next was Mr. Ponnuswami, aggrieved by this rejection, petitioned the Madras High Court. He petitioned for a writ of certiorari as expected to ask the High Court to quash the lower authority's order. The lower authority in this case, a quasi-judiciary authority, because it had the power to decide one way or the other. That authority, of course, was the returning officer. So the petition was made for a writ of certiorari to quash the returning officer's order. Mr. Ponnuswami also prayed to the High Court to order the returning officer to include Ponnuswami's name in the list of candidates for that upcoming election. And the High Court simply washed its hands of the entire matter, stating that it had no jurisdiction. The High Court specifically saying that we do not have the jurisdiction to do what you have prayed us to do. Interestingly, similar other petitions had been filed from several other constituencies for several other elections across the country, and each of them had been rejected by their respective High Court for the same reason, giving the same reasoning that the High Court does not possess the jurisdiction. All of this was happening at the same time because back then elections for the state assemblies as well as for parliament were held together, and this was of course the first time they were being held, and that is why suddenly there was this spate of applications of aggrieved would-be candidates, and each of them had been refused justice, as they claimed, by their respective High Court. So what is the reason? What is this lack of jurisdiction that the Madras High Court was talking about? It lies in Article 329 of the Constitution, specifically Clause B of the Constitution. The title of the article is itself Bar to Interference by Courts in Electoral Matters. It's a very thoughtfully created provision. A lot of thinking, a lot of analysis has gone behind the inclusion of this provision, specifically to prevent what Mr. Ponnuswami was attempting. The bar to the interference by courts in electoral matters includes a couple of things. Clause A, which is not relevant to our discussion, talks about the delimitation of constituencies. Clause A says that the delimitation will not be challenged in any court of law, and Clause B talks about overall the election matters. The first few words of Article 329 are notwithstanding anything in this constitution. No matter what is written anywhere else in this constitution about the jurisdiction of the High Court or the Supreme Court, for example, respectively Articles 226 and Article 32 and Article 136, each of which we have discussed and will continue to discuss in the channel. So notwithstanding anything in this constitution, so this is just like the ninth schedule, notwithstanding anything else, but this is not part of an amendment. This is the original provision as it existed from the day the constitution was written, and it states that any election question, any election to either the parliament or to any of the state legislatures shall not be questioned in any court of law. It can be questioned only through an election petition presented to an authority specified by Parliament or by the appropriate legislature, and that legislature will make a law which will tell us before whom we can question any particular election. To read the actual words of the provision 329 Clause B, no election to either House of Parliament or to the House or either house of the legislature of a state shall be called in question except by an election petition presented to such authority and in such manner as may be provided for by any law made by the appropriate legislature. So this, as you can see, does not on its own bar the High Court of its jurisdiction to issue a writ of certiorari. It does not. It does not specifically say that the High Court is not allowed. That is quite clearly going to be said by that law made by the appropriate legislature, and that law happens to be the Representation of the People Act 1951. Now there are two acts with the same name, Representation of the People. There is a 1950 Representation of the People Act and there is a 1951 Representation of the People Act. The reason for these two enactments is that first of all we needed to create a list of all voters, of all electors who had the authority to actually voice their opinion in that first upcoming election. That was the Representation of the People Act 1950. That act was enacted immediately because obviously enrolling all of those voters in the largest electorate that the world had ever seen, enrolling all of them was going to take some time, and that process needed to start immediately, needed to begin right away. So a separate enactment was first passed to ensure that that process begins, and then this second enactment, the Representation of the People Act 1951, was passed. That includes all the operational framework, operational as well as legislative framework. And Section 81 of this 1951 Act is what actually bars the High Court from interfering in election matters, and secondly, from bars any court really from interfering in an election until after it has taken place. So let's read it out. Section 81, Clause 1, presentation of petitions. This is the enactment as it then stood. It has since been amended, but not drastically. An election petition calling in question any election may be presented to the Election Commission. That was the case then, now that has been changed, by any candidate at such election or any elector within 45 days from, but most importantly, not earlier than the date of the election of the returned candidate. So who can file an election petition? Any of the candidates to that election, or any of the electors, any of the voters to that election. Any of us can file an election petition if we feel that some injustice has taken place. Who can we file it before? In those days it used to be the Election Commission. As I said, that has since been amended, and we will get to that amended provision when that comes into question before the Supreme Court. It was amended in 1956. But most importantly, this petition cannot be filed until that election has actually taken place. And here, until that election is not used, not earlier than the date of the election of the returned candidate. So there should be a candidate who has been declared to have won, to have returned. That is why we discussed that nomenclature first. So until after the candidate has been elected, only then can you file an election petition. So first of all, results of the election need to be declared. Only then can you question those elections. Nothing in between, nothing before that. No matter what has taken place, you cannot stop an election from taking place in the interim. If your nomination is rejected, or if somebody has been prohibited from campaigning in a particular area, for example, I don't know, the possibilities are endless really in our diverse country. So no matter what decision has been taken by the authorities, either the returning officer or any of the state infrastructure that is performing its duties under the instructions of the returning officer, no matter what decision is taken, none of those can be questioned until after the result of the election has been declared. Now, what is the reasoning behind this? We will discuss that in the next video, but for the moment, let us try and understand the predicament that Mr. Ponnuswami found himself in. He has been stopped from contesting the election. His nomination papers have been rejected by the scrutinizing returning officer, and he has no remedy before him, because the Constitution and the enactment made under the Constitution, this Representation of the People Act 1951, prohibit him from doing anything until after the election's result has been declared. And that is why he had no alternative but to question the meaning of the word election. As you can imagine, the enactment is quite clearly stating that nothing can be done until after the election has been completed. So you have, as a lawyer, you have just the one option available, and that is defining this term election, defining its scope, and somehow convincing the court that your petition lies outside the scope of that particular definition. And those were the arguments of Ponnuswami's advocates, that the term election in Article 329B and Section 81 of the 1951 enactment that term election encompasses only the result of the polling, only the final selection of the candidate, not the nomination for that election, not the rejection or scrutiny of the nominations for that candidate, not the model code of conduct, not anything else, just the actual result and final selection of the candidate. Only that is the meaning of the election. And the logic applied is that that is why the enactment says that the election can be questioned only after it has taken place. So what Ponnuswami is trying to convince the court is that election only means the actual result, and that is why the enactment states that the result can be questioned only after it has been announced. How can you question a result before it has been announced? You can't. So the result is equal to the election, and that is the only thing that is barred under 329B, that the result of the election cannot be questioned. That is, of course, not what the words state. The words in 329 are that no election shall be called in question except by an election petition, and the provision in the enactment states that calling in question any election. And Ponnuswami was saying that by election, the enactment, the lawmakers, parliament as well as the constituent assembly meant only the actual polling and not anything else that came. Election petition can only be questioning the final result according to Ponnuswami. That is why it is called an election petition, and that is why logically it can only be filed after the polling is over. But anything else, any injustice that is carried out before that, what is the remedy available to the candidates or indeed to the voters? If we find out, for example, that just before the election our name has been deleted from the electoral roll, what is available to us? Well, it is too late. You have to wait now until after the election has been completely carried out. You can understand the logic behind this. Obviously, the easiest way of preventing elections from happening is to keep on filing petitions before they actually take place. For example, imagine yourself to be the ruling party who have not really been ruling, who have been misruling, and therefore are quite certain that you are going to lose the upcoming election. So how can you prevent your loss? How can you ensure that you remain in power? By ensuring that the elections never take place. And how do you go about doing that? You just keep on filing such petitions, ensuring that everything gets stuck up in court, in some court or the other, and the usual tariq pe tariq keeps on happening, and the election never takes place, and you continue to stay in power. This is precisely what these provisions are attempting to prevent, and this was the question then before the Supreme Court, because the High Courts had refused to intervene, to interfere under their jurisdiction in Article 226, stating that 329 read with 81 of Representation of the People Act together bar their jurisdiction. This question was brought before the Supreme Court, and a 6-judge bench, so basically all the judges then except for Justice Vivian Bose, who must have been handling all the day-to-day matters. So all of those 6, led by the Chief Justice Patanjali Shastri and Sayyid Fazal Ali, who wrote the judgment, and MC Mahajan, BK Mukherjee, SR Das and Chandrasekhar Iyer are luminaries that we have been devoted to for the past few months when we have been looking at all of these judgments. So we will look at what this bench held in the next video. Hope you join me then. Bye bye.